Welcome back to Hexton Studios. We're here again with Combs Waterkotte, with managing partner Chris Combs and Joshua Boardman, who is the lead attorney for Illinois. Welcome, guys.
Thank you.
How are we doing today?
Good to see you, Scott.
Good to see you. Today we're going to cover sex crime charges in Illinois. What is considered a sex crime in Illinois?
Sex crimes can fall under many different categories, from a traditional thinking of sexual abuse or sexual, unwanted or unconsented to sexual conduct, all the way through charges related to online grooming, traveling to meet a minor. There's certain pornography charge, like child pornography charges, that would be considered sex crimes in Illinois. So there's it's a vast category of different types of conduct that can fall within those felony classifications.
What sex crimes are felonies in Illinois?
A number of them. You've got criminal sexual abuse, you've got criminal sexual assault, you've got aggravated extensions or enhancements of those types of charges. You've got charges like grooming. Online grooming is considered a Class 4 felony in the state of Illinois. So anything pertaining to typically unwanted conduct of a sexual nature, any sort of non-consented to physical, any sort of explicitly sexual imagery or anything especially pertaining to a minor, all of those are going to be felony classifications.
What is the difference between sexual assault and sexual abuse in Illinois?
Whenever someone is charged with sexual abuse or it falls within an abuse classification, it's looking more at the conduct. Is that the way that the law evaluates, or the way that a state's attorney will evaluate what to charge, was there something along the lines of fondling or something like that? It's unwanted conduct. Abuse typically does not rise to that level of any sort of penetrative actions or anything like that. So that would be the differentiation between the charging statutes.
What is criminal sexual assault in Illinois?
So criminal sexual assault is where you're going to have the unwanted or unconsented to sexual penetrations or sexual conduct or contact with sexual organs and things like that.
Well, where does that take us with what is aggravated criminal sexual assault in Illinois?
So not only is there going to be an allegation of some sort of sexual conduct, either through penetration or something along those lines, but there's going to be allegations of conduct. Oftentimes, to give rise to aggravated circumstances, you've got the use of a weapon or the threat of a weapon. The alleged victim can be someone that has a disability, or some form of handicap. There are age classifications. Is the alleged victim over the age of 60? Was there bodily injury as a result of the actions? If those allegations are tied in with the no consent and the penetration, things like that, then those can enhance the charge that the state's attorney has available to them.
What is criminal sexual abuse in Illinois?
Criminal sexual abuse is going to be based on unwanted contact without consent of a sexual nature, so sexual touching. So that can be fondling, that can be groping, things like that. Basically, physical actions that are unwanted or unconsented to that do not give rise to acts of penetration or things of that nature.
And what is aggravated criminal sexual abuse in Illinois?
Aggravated criminal sexual abuse is where you have the underlying allegations of sexual contact without consent or unwanted, but then you've got other circumstances or aggravating factors that could be the use of a weapon. It could include bodily injury of the victim occurring as a result of whatever they're alleging. It can be a special victim that includes folks that may have a disability or something like that. Mm-hmm. It can also include special victims based on age, over the age of 60, different classifications.
What is predatory criminal sexual assault in Illinois?
Predatory criminal sexual assault is you've got the sexual assault allegations, which would be unwanted, sexual penetration with the alleged victim. Predatory, though, is going to be available to the state's attorney where the allegations are that the defendant was at least 5 years older than the alleged victim, who was underage, or for example, or there's a classification also where they're under the age of 13. So there's going to be 5 years older, so where the ages are between 13 and 17. Then there's also statutory qualifications if they're under the age of that 13-year-old threshold.
So what is statutory rape in Illinois?
So Illinois doesn't necessarily define statutory rape within their criminal statutes. It's not, it can be a commonly described conduct, but that's not what they call it there. What they're going to define within that sort of definition is going to be their predatory criminal sexual abuse, predatory criminal sexual assault charges.
So that's different than Missouri then?
That would be a differentiation. Yeah, Illinois does not have a specific statutory rape statute on the books defined as that. Now, they certainly have statutes that control that kind of behavior, as many other, as all other states do. That's just not how they define it.
Can you be charged for a sex crime without physical evidence in Illinois?
Of course, and that doesn't even have to be Illinois, right? That can be any state. And when you mean evidence, your question was, can you be charged without evidence?
Correct. Without physical evidence.
Without physical evidence, yes. So, everyone these days watching CSI and everything, wants the DNA and this and that. But no, I mean, oftentimes, and I think Josh will echo this, there's not physical evidence in a lot of these sex cases. An allegation, a statement, is enough. A lot of people, that we talk to regarding cases, they're like, well, there's no evidence against me. And, we have to explain, well, there's not any physical evidence, but a statement is testimony, and testimony is evidence.
But can you be charged with a sex crime without penetration in Illinois?
Within the purview of sex crimes, you've got grooming charges, you've got child pornography charges, you've got traveling to meet a minor charges. You have all these different types of criminal behaviors that are sex crimes under the Illinois criminal statutes, but involve no penetration whatsoever. And also, sexual abuse has its own caveat within the Illinois criminal codes, and you can be charged with sexual criminal abuse, and it does not require any penetration. It is unwanted touching or allegations such as those.
But can you be charged if the other person consented?
We oftentimes will see cases where it might be a drunken night and intercourse happens, and at that time our client's saying, look, there was consent, but it gets tricky, and the next morning the alleged victim may say, look, I was too intoxicated to consent. I didn't consent. And I'll let Josh expound on that if you'd like to.
Yeah, and another classification where consent really does not matter is the alleged age, or the age of the alleged victim.
So they can't give consent.
They're not lawfully able to give consent if they're a minor. So in those circumstances, a defense of consent is not going to play.
Yeah, it seems like you would take that out completely.
It would,
if they're under a certain age.
Exactly.
Can you be charged if the accuser changes their story?
Yes, and again, not necessarily specific to Illinois, but, we see this all the time, where, again, I think it kind of goes to my example I was just explaining where, you have a drunken night. It seems like everything, there was no resistance. Everything seemed like it was copacetic. It was a normal sexual encounter. And then, the next day, you're hearing, well, I was too intoxicated to consent. You also can have allegations from minors who, again, can recant But at that point, as Josh was just saying, there's ages where you cannot give consent. So, if someone makes some type of statement that this happened and they're of age where they can't give consent, then they could still, try to recant. But again, they made the statement. It's hard to crawl back statements. And Josh, if you agree, disagree with me on that.
No, I completely agree. Yeah.
Can you be charged with sex crimes solely on an allegation?
100%.
Okay.
Absolutely. Yeah, and that's often when people call the firm, and oftentimes whenever we get our initial disclosures or initial discovery, the only thing that is going to be in that is some version of an alleged victim talking to a law enforcement officer, mandated reporter, and that's it. I mean, there's no physical evidence. It may be, it may be that the time frames are not well remembered, or the specific locations are not well remembered or well researched, and the only thing that's presented to law enforcement or mandated reporter is that they're alleging that some sort of unlawful conduct like that occurred.
And that's, and in all honesty, that is the best time to contact our firm, is if you get a call from law enforcement that says, look, we just had this allegation, or someone just made a report, get in contact with us, because what we do is try to shut that down. And what I mean by shut that down is you do not want to be talking to law enforcement. You always want to put an attorney between you and law enforcement, always. You can't get in trouble for something your attorney says. So you want the attorney to reach out to law enforcement on your behalf. You want that attorney to do everything they can to try to get some idea of the specifics of the allegation. And then we have some very highly recognized polygraph examiners that are extremely well respected. We use a gentleman who's an ex-sex crimes detective and sits on every board. And again, while they're not admissible in court, you sit for a polygraph, you answer the questions, you pass the polygraph, we can present that to the state's attorney or assistant state's attorney. And a lot of times that goes a long way in potentially shutting down, a weak case or a case that's based solely on allegations. So that is the best time to be hiring a lawyer.
Yeah, but you usually have to arraign it, right, to decide whether or not it should even go before a jury or a judge.
No, that's not true.
That's not true?
No, I mean, the way that this works, and this is, from my understanding, likely in every state, is some type of report or allegation is made. The veracity and truthfulness of that statement is obviously decided by law enforcement, and then ultimately a prosecutor, or in Illinois, a state's attorney, assistant state's attorney, who's going to then make a charging decision. So this happens awfully quickly, and things start to snowball very quickly. So that's why you want to put a lawyer in between you, law enforcement, state's attorney, so that, again, there's ways to try to shut this down. Whether you want to go in and give an audio video statement, prepare for that. Whether you want to try to control the narrative, give a written statement. But the days of just kind of asserting the fifth and saying, look, I'm out, doesn't play anymore. You've got an allegation of some type of sex crime. You're going to want to give your response to that. Because if not, guess what's going to go to the state's attorney or assistant state's attorney? The victim's allegation, or the alleged victim's allegation. And that's it. And, without you saying something, the only thing that they're going to be reviewing to make a charging decision is the alleged victim's statement. So the days of just asserting the fifth and saying, I'm not saying anything. Now, there are certain situations where if the evidence is overwhelming, or we're talking about DNA and things like that, you may not want to make a statement. But more often than not, you want your statement to be included. Would you agree, Josh?
Yeah, I would. And some of the advice that I give folks when they call in and say, well, I don't want to have the state's attorney only see one side of the story.
Right.
But sometimes that is unavoidable And then our job is to create that doubt and discredit that report, because I think a lot of times it is a natural inclination to go in and try to rid yourself of the allegations, because many times when people call, or most of the time when people are calling in regarding allegations, they're probably on the verge of losing their job. They've probably lost some form of, they probably have some form of reputational harm within their family or their community. So the first divorce, you see DCFS coming in and pulling kids out of homes, or or orders of protections. All of those types of things can certainly occur contemporaneously with these allegations, and that is before the criminal case even gets filed. And so, wow, all of these negative impacts on your everyday life can occur just purely based on allegations. A lot of times, individuals will want to run straight to the sheriff's department or straight to the state's attorney's office and try to rid themselves of these allegations. But those folks are trained in tripping you up and creating the narrative that they need to file their case or pursue their case.
Yes, so, law enforcement is looking to build a case. Law enforcement is not looking to help you. They're looking to build their case. Like Josh said, they're trained to ask certain questions that don't have any good answers. Like he said, trip you up, things of that nature. So, when you've got a sex crimes detective who's been doing this for decades, and they know how to ask questions that don't have any good answers, or they ask the same questions in slight variations, things like that, that's where things can go south real quick.
Can sex crime charges be reduced in Illinois?
Yes, just like any other state, charges can always be reduced. So in Illinois, that's something that our office is always working on. We go into every case looking for a dismissal, or to shut down charges ever even being filed. However, I'll let Josh, echo this, but just like any other charge, sex crimes can be reduced to a lesser charge with lesser fines, lesser penalties, avoiding potential jail time and other consequences.
Yeah, and oftentimes reductions are a result of one of two things occurring. One of which is an amendment by the state's attorney's office. The second of which, they're essentially byproducts of one another. But sometimes the state's attorney, as they are developing more and more evidence or more of a factual background from their law enforcement, their witnesses, I have had it several times where a sex crime was charged, but then prior to a preliminary hearing or as a part of a plea deal, they amended that charge to non-sexual contact or non-sexual behavior based on the strength of the allegations. Sometimes perhaps there was some form of physical dispute or something like that, but it wasn't sexual in nature. So then they can potentially amend that to peace disturbance or an assault or battery or something outside of a sex crime realm. So sometimes the state's attorneys will do that based on their own investigation of their own facts, but then oftentimes whenever people get in contact with our office and we're able to do a deep dive into all the discovery and we start pushing back on maybe the chronological discrepancies between witness statements or different things like that, then they can amend those charges because frankly they don't want to go to trial and lose on those. So they're going to try to save face by amending those charges to charges that if they do have to go to trial, that they think that they could succeed on those.
They're trying to win.
Exactly.
Yeah. And maybe it's a conviction for the state, but for our client, they could be avoiding having to register as a sex offender or, something of that nature. And what really sets Combs Waterkotte apart from any other law firm that I'm aware of is you get 5 or 6 levels of review of your discovery in our firm. So everything the state is using to charge you, when that comes into our office, that's reviewed by a law clerk, that's reviewed by a senior litigation paralegal, That's reviewed by our investigator, who's former law enforcement. That's then reviewed by an associate attorney, and then it lands on a partner's desk. So you're getting a very thorough review of any allegation against you.
Well, let's talk about police investigations and arrests. Can the Illinois police investigate me without telling me?
Yeah, absolutely. And oftentimes they do, because why in the world would they want to tip you off and give you an opportunity to try to start combating their potential allegations? So many times, by the time that someone has called us as a result of law enforcement contacting them, they've already met with potential witnesses or victims. They've already built a timeline. They've already got potential DNA testing in flux. So yeah, there's many building blocks of their investigation that occur before they even reach out to the potential defendant.
Should I talk to detectives?
Absolutely not.
Yeah, if I'm charged with a sex crime? In
Yeah,
Illinois?
In no world.
I hate to
Don't
talk.
even finish the question.
I know.
That's a no, an absolute
And I
no.
hate to talk over you, but
No,
yeah,
that's
I mean,
okay.
That's just an absolute no. I mean, all you're going to do is dig your own grave. Again, that's where you need to hire an attorney and get an attorney involved. And going back to what we had just said about questions with no good answers, things of that nature. And police are allowed to legally lie, So, look, we've got your DNA. Well, they may not have the DNA, but boy, if you think they've got the DNA, they may elicit some type of confession. So, no, the answer is a hard no.
What do you do if a detective wants to ask questions?
Call one of us. Yeah. No, honestly, if you are contacted by a detective or law enforcement, the first thing that you should do is say, at this point in time, I'm going to take down your contact information, but I am going to review this information with an attorney and call an attorney, and then that attorney can act as a liaison or a mouthpiece for whatever response you want to have. And the smart answer may sometimes be, we're not going to give a response, but whenever you are contacted, the first thing you should do is delay that communication as long as you can, with the reasoning that you're going to consult with an attorney.
And yeah, just to expound on that a bit, it goes back to what I was saying. When you get that phone call, that's the best time to hire a lawyer. Oftentimes we have people who wait or are hoping that this is just going to go away. It's not going away. So it's the best time to hire a lawyer because the case is, somewhat in its infancy, and it gives us a chance to potentially shut it down. And if not shut it down, get way in front of it, as opposed to now I'm charged, and then we're dealing with detention hearings and, things of that nature.
Can the police record my interview without telling me in Illinois?
Yeah, so you can expect that they will record audio. Oftentimes you're taken into interrogation rooms that have both audio recording and video recording.
Which law enforcement calls interviews, right?
Yeah, exactly.
So to them, it's
Yeah.
an interview room and it's an interview, but believe
It's
me,
a recorded conversation.
it's an interrogation.
They don't even need to say that they're recording it. They just can.
Yeah. So, I mean, it's not some sort of formal process of them announcing, oh, here's what we're asking, why we're asking it. I mean, they are looking to trip you up. They're looking to, like Chris has said, elicit some sort of response and then flip around and glean that information, go back and rewatch it, compare it with other conversations they've had with their witness and build that case. Oftentimes, part of the initial discovery package that we get is the interview with the witness. That's oftentimes audio and video. And then also, if our client, in my opinion, made the poor decision to go into some sort of interrogation or interview, oftentimes we'll get a copy of that tape as well.
By poor decision, what do you mean? Alone?
Alone, without counsel. Yeah,
Right.
without asserting their right to counsel at that stage of the case.
Can the police arrest me without DNA evidence?
Of course. We've touched on this before. Everyone these days with the TV shows and things like that think that it requires some type of DNA or some type of physical evidence. But as I mentioned, allegations are evidence because testimony in court is evidence, and there's people sitting in prisons all across the country based upon what someone said, what someone testified to. They do not need physical evidence or DNA. Would you agree, Josh?
I would agree. I mean, is DNA sometimes a silver bullet for the state's attorney? Sure, but oftentimes with these sex cases, there's not DNA, and there never will be DNA because either the type of case or the criminal behavior did not require any sort of DNA evidence. So, yeah, I mean, many times convictions to sex crimes occur without any DNA evidence whatsoever.
Can the police take my phone during a sex crime investigation in Illinois?
They can. They would need to obtain a warrant for that. Or I've also had instances where, once again, law enforcement is not there to educate you on your constitutional rights. So I've had cases where law enforcement will ask for a cell phone, and individuals thinking that they have to obey law enforcement will just give their cell phone over, not realizing that law enforcement officer would then have to submit a request for a warrant. A warrant would have to be signed off based on the existence of probable cause to search that cell phone, just as you would a vehicle or a residence or something along those lines. And yeah, the law enforcement's not there to educate you on the right and wrong answer. So I've got cases right now where cell phones were willingly given to law enforcement.
And I can't tell you how many times I've been on the phone with a potential client, just even on like a DWI, let alone a sex crime, and I just asked him the question, did you blow or not? I didn't know I had a choice. You always have a choice, always. And again, like Josh said, law enforcement is not there to educate you on your constitutional rights. So they may say, well, I need to see your cell phone. Okay, sure, here you go. They may still have to go get a warrant to search that phone, but now they have it. It makes their job much easier. So again, a lot of people just think they don't have a choice. They have to cooperate. And again, they make poor decisions.
You just don't know the answers, right?
Sure, and that's kind of why we're here.
That's
to
the
try to
scary
educate
part.
people.
Yeah, absolutely. Because that's the scary part. You get in this situation and you think they demand you to do something, tell you have to do this thing because they're obviously making up the rules and lying. And as someone that would think, well, if he tells me I'm supposed to do that, they're the police. So that's what I do. That's terrifying. I mean, this is great to have you guys here so that we can have this conversation, because it's so hard to imagine in being in that situation in the first place, but then to succumb because you just feel like this badge means I do what they say.
Yeah, and it happens.
So often.
Yes, way more often than you'd ever imagine.
Can the police search my home in Illinois during a sex allegation or an investigation in Illinois?
Yeah, they can. The two ways in which they'd be able to is, one, they knock on your door. You, somebody that has the ability to let them in, legally speaking, I mean, has some sort of connection with that home as far as residency, lets them in, and so then they do a search via consent. That would be one avenue. The second avenue is if they've been able to obtain a search warrant based on a previous probable cause finding in order to come in and locate whatever they're claiming is within that home as potential evidence. So, go ahead.
I'm asking you as the head of our Illinois department, does search incident to arrest, does that apply? Meaning once they're arrested, can they go ahead and search the home?
Yeah, they can then utilize that arrest and the allegations or the findings or the probable cause within the context of that arrest to then go search for other evidence that would be related to those allegations for which you were placed under arrest for.
And then again, this is more a question to Josh, but in computer sex crimes, I know that at least in Missouri, they will ping, to law enforcement if there's some type of computer sex crime. Oftentimes they have a warrant, but sometimes they'll just come in and seize electronics. Is that correct?
Yeah, and then
Based on the allegation.
based on the allegations, then try to create the probable cause afterwards. And so it's kind of putting the
It's a
cart.
little bit out of
well,
order.
It's putting, to use the phrase, it's putting the cart before the horse.
Yeah.
To some extent.
But it happens. I mean, we
Yeah.
see it.
It's essentially a fishing expedition because they're claiming, well, we think there was a ping, so we think there's something here. Don't know quite what it is, but we need that device to try to narrow it down. When in other criminal contexts, warrants are not obtained that way. You know, I mean, if you're coming in specific for a drug search or something, you have to list what you suspect to be in that location or listed on the warrant. Oftentimes with these electronic devices or storage on the cloud or whatever, it tends to be a more broad scope, and then they try to justify narrowing it.
What is a search warrant? When is it required in Illinois?
A search warrant is a permission document, essentially, that's based on probable cause that something will be located or that something exists. And I'm speaking generally because they are pretty general. I mean, it can be within the classifications of sex crimes or drug crimes, gun crimes, what have you. But essentially, it allows law enforcement to search and investigate these places that are otherwise constitutionally protected, like your home, your vehicle. It could be a cell phone or something like that. But it has to be signed off by a judge, and then they've got to demonstrate to the judge the probable cause finding, and then they execute that search warrant at the time of the search.
What happens if I'm arrested for a sex crime in Illinois?
Call an attorney.
Yeah, yeah. First thing. So what they'll do is they'll arrest you. They'll take you into the local precinct or sheriff's department or whomever is doing the investigation. They will do their initial booking process. They've got your fingerprinting and all of that. But also at that point in time, I mean, they may try to interrogate you. They may try to investigate the claims further, see if you'll admit to anything. But in Illinois, after you are arrested, then you are going to be placed in custody for at least a period of 48 hours prior to your 24 to 48 hours kind of, and some of that depends on the court scheduling as well, but for your detention hearing as to whether or not the state's attorney is going to file charges within that time, not file charges within that time. If they do file charges, are they seeking to have you detained prior to trial? All of those things can occur shortly after being arrested.
Do I have to give a DNA sample if accused in Illinois?
No, the answer would be no, not unless they have a search warrant for your DNA. It goes back to, not knowing your rights and, doing what law enforcement says because you feel you have no choice. But without a warrant, you do not have to give your DNA. Would you agree, Josh?
I would. I mean, they may try to take a hair follicle or blood draw or something like that, and they've got to have a warrant for those types of actions, those types of collections.
What happens if I'm falsely accused and the police contact me?
Whether you're falsely accused or there may be some accusations that you are concerned about, it makes no difference on the type of response that you have, which would be to not jump into some form of elaboration as to why you believe that you're falsely accused. Get on the phone, call an attorney, have that attorney present the definitive evidence that the accusation is unfounded, create any sort of doubt or create any sort of discrepancies, create that alternative narrative that's going to demonstrate that those accusations are in fact false. But you should not be the one to take up your mission and prove why you believe those allegations are false. Because oftentimes people will try to do that, obviously to save face or save reputation or reasons that are completely well-founded, but in the meantime they get into a conversation with a highly trained law enforcement agent or officer, detective, or whomever that is going to ask them questions that they were not anticipating, and they may end up answering those questions in a way that could be incriminating or more so helping law enforcement build their case than demonstrating that there was ever any sort of false allegation.
And I would say sometimes that is the toughest part, is when someone is falsely accused, because again, echoing what Josh just said, what do you want to do when you're falsely accused of something?
Defend yourself.
Of course, you immediately want to prove that this is false. However, that is when you have to stop, take a deep breath, and as Josh said, put an attorney between you and law enforcement.
Can I refuse to give a statement to police?
100%.
Absolutely.
Yeah.
Yeah.
And
Yeah.
you should.
That would be our recommended advice every time. Come to us, tell us your side of things, tell us what you're concerned about, what you're not concerned about, what they have put on your radar, and then let us curate the narrative, let us control how those interactions are going to be moving forward during the beginning stages of an investigation or a case.
That's a fantastic answer. I completely agree.
Well, let's talk about the Illinois court process. What happens after I'm accused of a sex crime in Illinois?
After you were accused or after you've been arrested?
After the charges are actually filed.
After charges. So if charges have actually been filed, it means that the statements or whatever evidence that law enforcement was able to collect incident to their search has been handed over to a state's attorney or assistant state's attorney, and they are now filing a sex crime based off of those allegations or that evidence. So once those charges have been filed, it is likely that you will be detained at that point. If you were arrested, then you'll be detained, or a warrant will issue for your arrest, and then you're subsequently detained. The clock starts ticking once you're detained for a pretrial detention hearing. And so you are advised of what you're being charged with. Also, you have an opportunity to have an attorney argue at a detention hearing. The sole purpose of that detention hearing is to determine whether you are released prior to your scheduled trial or whether you're going to remain in custody before trial.
What happens at an arraignment? Sex crimes in Illinois.
Of course. So an arraignment for sex crimes is similar to an arraignment of any type of crime, which is where the judge is going to advise you of the charges that are being levied against you, ask you if you understand those charges, ask you whether you plead guilty or not guilty to those charges. Basically, create an awareness and advise the defendant of their rights and also what they're being charged with.
And oftentimes, if you have private counsel, you're going to waive arraignment, because who's going to stand in front of a judge and have the judge just read you the charges, ask you if you understand them, and give you the range of punishment? I mean, that's what we're here for, right? So oftentimes an arraignment is a hearing that we waive and enter a plea of not guilty on your behalf.
Always.
Yes.
Will my sex crime case go to trial in Illinois? How do I know?
Well, I think that question can be answered for any charge in almost any state, which is your case going to proceed to trial? Well, that depends on a multitude of things, of course. The evidence, potential plea offer by the state's attorney or assistant state's attorney. It is always ultimately up to the client if they want to take a plea deal if we're not able to secure a dismissal, or take it to a full-blown jury trial. That is always the client's decision. It is our job to work up the case for a dismissal or for, reduced or lesser charges. Mm-hmm. And then it is always ultimately the client's decision. I can live with this deal, or I want to proceed to a full-blown jury trial. So it's ultimately the client's decision, but you really don't know until you get neck deep in the case and really start working it up. Josh?
Yeah, I would say that our approach is to treat every case that comes in the door as a trial case from a preparation standpoint. But you're going to reach a point in time where you're going to sit down with your client, the defendant, and say, here is where we are with plea negotiations. It's probably not going to get better than this. Here's where we are with being able to secure dismissal. They're hanging on to the charge. They're not willing to. Here's where we are with the strength of the evidence. They're willing to go to trial over the strength of the evidence. And then, as Chris said, present them with the most well-described and well-educated options. But then ultimately it's up to the defendant and what kind of risk appetite that they have and what they evaluate as the strength of the evidence against them versus whatever offer the state's attorney is requesting that they plead to at that time. So we prepare every case as though we could, but that certainly doesn't mean that every case does.
And one thing I would say just quickly is that a lot of cases don't go to trial as much as they used to for a variety of reasons. One is something that Josh just touched on, which is risk tolerance or risk appetite of the client. You've got the first year plea deal, you're rolling the dice. And let's say you get a reduced plea deal, right? Well, if you decide to go to trial, you're going to trial on the original charges, not on the reduced charge. So, again, you have to remember that. But the one thing I want to touch on is that cases that you see go to trial the most are likely sex cases. And the reason for that is the punishments are so severe. So if you're looking at 20 years, you're likely going to go to trial. So you do see a lot of sex cases go to trial. Would you agree with that? More than any other case type.
I would, because there's also the extremely punitive requirement that there's sometimes at least lifetime registries on Illinois sexual registry lists and things. So people get in that position and go, I don't know why I would ever willingly plea or willingly accept those types of prohibitions on my freedoms and liberties. I'm going to take a chance at trial. Happens all the time.
If you're on lifetime registration, I mean, you have zero constitutional rights. I mean, they're gone. So you're living your life without any rights.
Wow.
Yeah.
How long do sex crime cases take in Illinois?
It can completely vary, but they often take longer from the inception of the case through the disposal via a plea or via a trial setting. They often take longer than cases such as a DWI or possession case. And the reason for that is based on several factors. Mm-hmm. One of which is how serious the allegations are when it comes to sentencing. So depending on the sex crime, you could be looking at mandatory minimums for prison time. You could be looking at sex offender registry requirements. So you want to make sure that you have all the evidence and all the details and all the facts before either disposing of the case via a plea or trial. And that is a very time-consuming process for the state's attorney's office because they may be on a delayed schedule waiting on DNA evidence. There may be witnesses that are cooperative or uncooperative, and then they're trying to juggle those schedules. Obviously, as a criminal defense attorney, we're not trying to rush through any of the allegations or any of the fact collection or data collection before disposing of a case. So there's not a good answer to, it's done in 12 to 14 months. But typically the lifespan of these serious sex crimes is longer than many other types of crime classifications.
And one thing I would say that I find myself saying constantly is that you never want to rush a case at the expense of the outcome. Mm-hmm. Now, that's much easier to tell someone who's out on bond, right? If you're sitting behind bars, it's a little different, you know, to explain, look, we don't want to rush things at the expense of the outcome. But again, you know, and I'm beating a dead horse, but you do not want, particularly in a sex case, to rush, you know, the case at the expense of an outcome.
Can sex crime charges be dismissed before trial?
Yes. In Illinois and anywhere, you know, charges can be dismissed. And at Combs Waterkotte, you know, we go into every case, like Josh said, prepping to go to trial and looking for a dismissal.
What is a preliminary hearing in Illinois court cases?
A preliminary hearing is going to be a specific type of hearing to determine whether there's probable cause for that case to move forward. So based on the allegations. And oftentimes you're going to have, in sex cases, you're going to have law enforcement testimony. You're going to have potential witness/victim testimony. You can have, if there were individuals like social workers or other types of witnesses, they can testify. And it's the state's burden to demonstrate that there's a probable cause that the allegations or the actions that you've been accused of actually took place to where it can advance farther in the lifespan of the case. If it reaches that threshold and the court does find that the case needs to be what we would say kind of bound over into the second half of its lifespan, at that point in time you can enter into a plea, you can set it for trial, those types of options. But if there is no probable cause finding, then the judge is required to dismiss the case at that point in time. Now, they can try to refile it under a different charge or ways that they believe the evidence could meet the elements of different types of charges. But we prepare intensively for preliminary hearings because oftentimes that's the first bite at the apple to really get an idea of how credible the witness is. How much information does law enforcement really have? Is this all he said, she said, or is there some part of some sort of third-party verification of the allegations? So it is a mini trial that we certainly prep for.
And it's our first shot at getting a dismissal.
Yeah, correct.
Win it early.
Correct.
What is discovery in a sex crime case?
Discovery is going to be is going to be a synonym with evidence. So whenever we get into a case, we'll file a motion for discovery, and what that does is it puts the state's attorney's office on notice that we are entitled to all the evidence that can or would be used against the defendant. So that can be oftentimes police reports, that can be any sort of DNA data or DNA testing that's been done, that can be pictures, videos, text messages, social media posts, like I said, witness statements, anything like that. So discovery, think of discovery as all the evidence in the case.
Can the state drop sex crime charges in Illinois?
You should not go into a sex crime case automatically assuming that they are going to drop it, because based on the classifications of sex crimes, they are very serious felonies. And so state's attorneys often highlight those types of cases as one that they're dedicating special attention to. But cases are dropped for a number of reasons. One, law enforcement may get a report, or a mandated reporter may get a report from someone that has levied some sort of accusation of a sex crime. The state's attorney's office may be investigating that more deeply, and there may be inconsistencies. There may be legitimate alibis. There could be defenses like consent or something like that that are presented to the state's attorney's office, and they go, we don't feel as though we can meet our burden of proof at trial, which is a constant thinking of theirs or mindset of theirs, so they'll dismiss it. Do not expect it, but it can happen.
Can a sex crime case be dismissed if the accuser doesn't show up?
They can, and frankly, it depends on what other kind of evidence is presented in that case. But if the sole evidence is just the witness testimony, and that witness then explained the circumstances to law enforcement, well, the law enforcement officer themselves is not able to satisfy the burden of proof through evidence because they're just hearing that from the witness. So if the witness is not there to personally testify as to what allegedly occurred, then the state has a very difficult time of meeting their burden.
We've got hearsay issues, right?
Exactly. So, I mean, chances are if the officer even tried to come in and say, well, I was told this, we could object, and the judge would probably sustain those objections without the sort of the present impressions and the present, at least the descriptions and the statements from the witness themselves. And sometimes, frankly, that is a strategic move on our part, and it brings a certain element into the case. Okay, do we set this case for trial because the alleged victim or witness or whatever now has left the state or is not cooperating with a crime victim advocate or Have they came back and recanted their statement formally through some sort of affidavit process? So yeah, sometimes there is a certain amount of bluffing that's done with setting a case for trial, knowing that the witness or the victim may not want to participate in that.
Do sex crime cases get special prosecutors in Illinois?
I think just like any other state, you typically see teams in state's attorney's office, prosecutor's office, DA's office, where you've got a group of state's attorneys, assistant state's attorneys that solely work on domestic violence cases, solely work on sex cases. Sex cases are almost a subspecialty in criminal defense. You'll find that there are some defense firms that don't do sex cases because it is a subspecialty, and there are a lot of different laws that apply to, like rape shield laws and different laws that apply where there are roundabouts for the state to get in hearsay statements. And so if you're not well versed in sex crimes, you should not be doing them
Right.
as a defense attorney. But it is not unusual for a special prosecutor to be brought in for a sex crimes case. Would you agree, Josh?
I would agree. So in counties with larger populations, oftentimes there are dedicated teams. In more rural counties where sex crimes are at least alleged or charges are brought, it's not uncommon for special state's attorneys to come out of the Attorney General's office or come over from a different county where someone may have experience in sex crimes where a state's attorney may not have experience. So I would say that state's attorneys' offices are responsible for filing the charges, and so there are some counties that I've encountered charges where there are not dedicated teams, but there certainly can be special teams or special state's attorneys that are assigned to these types of cases.
Can my sex crime case be transferred to a different courtroom or go before a different judge?
Yeah, so under the law, there are change of judge procedures, and those are based on statutory factors. I mean, that there could be based on bias or actual conflicts of interest or things like that. So if, as part of our job is obviously to understand which judge we're before and determine whether there needs to be a change of judge based on any of those circumstances. But yeah, to answer your question simply, yes, judges can be changed throughout the process, or sometimes different judges are assigned, what have you.
In courtroom, what's the significance of different courtrooms if it's changed? Is that just based upon the judge, or is there something specific about that?
There's really nothing specific about it.
Okay.
Yeah, oftentimes the courtrooms are pretty uniform. It just depends on which judge's courtroom that you're in front of, which judge is going to hear that case. So Illinois doesn't follow the same sort of associate circuit or circuit court level that even like a neighboring state like Missouri has. Whereas in Missouri, you've got associate circuit, and then it gets bound over to circuit court. And many times in Illinois, especially in rural counties, the same judge will hear a case through the detention hearing all the way and will be the trial judge at the end.
All right, let's talk about bail, pretrial release, and orders of protection. Can I get bail if I'm charged with a sex crime in Illinois?
Well, Illinois operates under the Safety Act, which is an evaluation not of bail or bond, as you would think of in other states, but it creates a question of detainability. So is the state's attorney's office seeking for a pretrial detention, or is there permissions for pretrial release? So it's not as though the judge will put a $100,000 bond on somebody's head for a sex crime. It's within 48 hours, you're going to have a detention hearing to determine, one, is there a flight risk? Two, does that defendant create danger to a person or persons within the community?
Will I be held in jail until trial for a sex crime in Illinois?
If the judge determines that that you present a flight risk, then yes, you can be held in jail all the way up through your trial date. If the judge determines that you are a threat to the community, or you're a threat to a specific type of person, or just a person in general, I've had that where there may be just one isolated alleged victim, and there are really no allegations of anyone else, but the judge still chooses to detain based on allegations against that one person, because the judge may feel that whatever behaviors towards that one person could translate to other people within the community. So to answer your question, yes, for serious felony classifications like Class X felonies, Class 1 felonies, it is not uncommon for judges to hold someone in custody until the day of their trial.
Can I be denied pretrial release in Illinois?
The short answer is yes. If the judge makes a determination that, again, you're a flight risk, a danger to the community or yourself, also look at criminal history, things of that nature. If the judge determines those things, then yes, you can be denied any type of bail or release. It's my understanding, and this question would be for Josh, I think Illinois operates on kind of a cashless bail. They just look at the kind of safety issues. Is that correct?
Correct, yeah. So what's going to happen is detention hearings throughout the lifespan of a case. And so I believe your question was, can you be denied release?
Correct.
Before
Pretrial release, correct.
Pretrial release. Yeah, absolutely. The judge is going to, for one thing, that legal mechanism or that legal question of whether or not you're going to be released is brought by the state's attorney's office. They have the burden of proof that through their petition to detain, that the defendant poses a present risk to a person or persons within the community, that the defendant poses a flight risk, and they cannot be trusted to participate in the court proceedings prior to trial or trial itself. And so if the state's attorney is able to provide a viable enough argument as to either one of those things, then they look at community ties, they look at employment, they look at substance abuse issues, alcoholism, they look at criminal history, they look at mental health specific to sex crimes. Oftentimes in sex crimes, judges look at access to technology and all of those types of things. So they're going to the judge is going to make an evaluation, and if the judge finds that they do not believe that the defendant can be trusted to stay local and participate in the proceedings, or if they find that that defendant poses a threat to the community or to a certain person, then they'll deny him and they'll sit in there prior to trial. Now, you've got speedy trial protections and things of that nature, but yeah, you can expect to sit in jail until the day of your trial.
Wow. What conditions can a judge impose on an Illinois sex crime case?
They can get pretty creative. For example, I've got cases right now where allegations pertain to a lot of online usage, but only online usage. So the judge in those cases let them obviously go on pretrial release terms, but those release terms are you're not able to access the internet, or you're not able to have you have to turn in your cell phone to whomever, and you have to go get a flip phone and things like. So judges have a broad amount of discretion of conditions that they could impose that they feel are curated towards the allegations.
GPS monitors.
GPS monitoring, curfews. I have had judges essentially say that client-facing individuals that may be like traveling salesmen or whatever are not permitted to continue in that occupation because there may be exposure to minors or something like that. So I've had judges. I don't want to say that the answer is endless, but there are many creative things that judges can do to put conditions on pretrial release.
It sounds like it's based predominantly on the severity.
It's based on the severity, it's based on the conduct, and it's based on what the judge thinks that they can impose to curtail any continued behaviors that they would have a problem with prior to trial.
Can the court order no contact with the accuser in an Illinois sex crime?
They almost exclusively do. That's kind of one of the given terms, and then they funnel down from that.
What is a criminal no contact order in Illinois?
A criminal no contact order is going to be essentially a restraining order, order protection that is the petitioner, and that can be state's attorney's office or DCFS or something like that, where basically the court will order, it's based on the same findings that a civil order protection would be based on, or a civil no contact. But it prohibits oftentimes being within 500 feet of the residence or the location that would be germane to the allegations, no contact directly or indirectly,
No third-party
no
communication.
third-party communications. There'd be other restrictions on liberties, where you can travel, when you can travel. You have to surrender in Illinois, it's a FOID card, your firearm identification.
Passports.
Your passports, your firearms. Wow. So the state can bring that and act as the petitioner on behalf of the alleged victim, that those will be put in place during the lifespan of the criminal case.
What's an order of protection, and how does that affect a sex crimes case?
I'll let Josh handle this.
Yeah, so an order of protection is essentially going to be, in its most general sense, an order of protection is going to be based on findings of stalking, harassment, abuse, those types of, I would call those general terms or general allegations. It is a civil mechanism by which a petitioner can go in and say that they feel threatened or abused or harassed or stalked. And oftentimes the allegations that they put in those petitions are identical to what they've given to law enforcement or the state's attorney's office have. But what it does is it just acts as another shield for that victim or for that witness based on those allegations.
Can I be forced to leave my home because of allegations of...
Absolutely. So if the petitioner, let's say it is a romantic couple or a married couple, and the petitioner puts in there that, that they basically don't feel safe or they feel harassed or stalked or whatsoever, and their home address is listed, then the judge can order that the respondent not be allowed within 500 or 1,000 feet or whatever of that residence. So you got to pack up and live elsewhere. Yeah.
Can I see my kids if I'm accused of a sex crime in Illinois?
Depending on the circumstances and depending on how valid or reasonable the judge finds the petitioner's arguments, within the Illinois petition for an order of protection, there are provisions restricting visitation with children, temporary custody bestowed, temporary child support ordered. So if the judge finds that those are relevant protections, then yeah, it can act as essentially as a temporary custody order.
What happens if I violate a no contact order?
First violation is going to be a misdemeanor, and then subsequent violations of that can lead to more significant charges.
Well, let's talk about evidence, consent, and defense strategy. What defenses are available with sex crimes in Illinois?
So some of the ones that you hear frequently would be consent, that prior to the allegations there was a history of consent, or during that actual incident that's being flagged that there was consent. Oftentimes defenses come about as a result of trying to discredit or weaken statements. I mean, because so many statements are sort of he said, she said, it's really, creating a series of discrepancies within that, because it does happen where false allegations are raised out of, especially like family law cases and things like that, where that becomes a pretty quick avenue to get custody of your kids. Fire off an allegation about something, and then suddenly an order of protection is granted, and then you're being investigated. So, yeah, there's defense. I mean, obviously you have your alibis. I just wasn't there. It just wasn't me. There was consent for whatever allegation was levied. That the statements are not credible, that the timeline doesn't match up, anything like that. And frankly, that's our first thing that we do is compile every defense that can be utilized in one of these cases.
Yes, I mean we'll investigate the alleged victim, of course, and I mentioned the polygraph, something that we may do privately, not the state's polygrapher. On computer sex crimes, we will engage our own private computer forensic personnel. So it's kind of endless. Obviously we go to the ends of the earth and leave no stone unturned on these cases.
How does consent work under Illinois law?
Consent would be where there's an allegation of some sort of physical contact or something along those lines, that whatever that physical contact is or would be agreed upon by the alleged victim or witness, or that they didn't express any sort of disinterest, or they didn't tell you to stop, or were not welcoming or encouraging. And frankly, that can mean a lot of different things based on the interaction. But certainly consent is one of the defenses that often arise with these types of crimes.
Can consent be used as a defense in Illinois?
Absolutely. And you will see that often where, I think Chris has mentioned it, where someone, I think the classic example is maybe a drunken night where there was consent and then the next day there's not, or that they claim that consent was withdrawn. You're going to look at circumstantial evidence. Was there an ongoing romantic relationship? Was there any sort of social media or text messages or pictures or videos that kind of create this context or these circumstances under which consent would be reasonable? Or was there a significant amount of prior consent before that would sort of demonstrate perhaps a discrepancy versus someone claiming that there wasn't consent? So it's a deeply factual analysis based on what the report is, what the allegation is, and how we respond to it.
What if both people are intoxicated?
In those circumstances, the state's attorney is going to look at circumstantial evidence and determine what level of impairment. They're maybe going to look at what was consumed beforehand, the chronology of what occurred and what occurred before that. And if they make a determination that the level of impairment was such where consent could not be given, then that's certainly going to help with their charging decisions.
What if there are texts and messages showing consent?
Well, oftentimes that comes about at a certain point. Was there consent? Is it expressly represented that there was consent? But is there an allegation that consent was withdrawn in the moment? And that's all part of the circumstantial evidence that surrounds the affirmative defense of consent whenever one of our clients or whenever someone facing one of these charges wants to assert that defense.
And oftentimes, I'll see in the text messages when both people are highly intoxicated that the alleged victim, the female, the text messages oftentimes are kind of questioning it, which can be helpful, like not outright saying like, I was too drunk to consent, what did you do to me? It's a lot of, oftentimes I see, kind of just questioning what happened the night before, and not outright saying, look, I was too drunk to consent, more so like, hey, what happened last night? Like, I was awfully drunk, and and so, but yeah, text messages certainly can be evidence and come into play.
Yeah, it sounds like it would be complicated because of context.
Yes, and context is huge, as Josh touched on.
Right.
It's going to be very circumstantial, and they're going to look at the veracity of and truthfulness of both persons' statements, and
Right.
And level of intoxication.
Well, can social media messages be used in court?
Yes, of course. Social media is highly involved in a lot of these cases. I think we see social media as evidence as much as we see anything else these days. Would you agree?
Yeah, especially with the proliferation of apps and platforms like Snapchat that allow for messages and pictures and videos, and they disappear or they're not, they're not saved. So, like Chris said, more often than not, the timeline or the context of the interactions between individuals is going to involve text messages, social media, because frankly, we get way more calls around interactions or allegations where the individuals knew one another and there was an existing relationship of some kind than sort of the man loose on the street type of horror stories that you hear. So because we're getting so many calls where the context is absolutely at the forefront, social media is driving that, text messages, things like that.
Can deleted messages be recovered in a sex crime case?
Or what I've seen previously is as there's an investigation into allegations, and that can be from the side of law enforcement, or that could be from the side of perhaps one of our potential clients in a self-preservation type of action, or in either an alibi or whatever they're trying to assert in defense. They can either request their own cell phone records, or we can send out subpoenas, things like that.
And I've had cases where I've had clients get scared, delete messages, and we hire a computer forensic expert to do whatever they can to try to recover those, because sometimes they can be helpful to our case. So definitely there are times when they're recoverable, but a lot of times they're not.
How important is DNA evidence in a sex crime case?
Well, I would say that it is critical. Obviously, as Josh had mentioned before, it can be a silver bullet, for the state's attorney or assistant state's attorney. However, we recently had a case where DNA was on the genitals of the alleged victim, and we were able to secure an acquittal based upon how it was collected, how it was tested, so it's critical that you get an expert, someone who knows about, the DNA collection process and preservation and things of that nature. And that was what Josh had alluded to earlier. That was a nasty family law case where, because one parent wanted custody, they lobbied an accusation, that the husband was, having inappropriate sexual contact with one of the children. And again, we were able to secure an acquittal. But so it's not always a silver bullet. And I'll let Josh expound on that a little bit. DNA, I guess, the important.
The important considerations would be, one, the custody and control of how that DNA was collected. Was it done in a way that was in accordance with medical and scientific standards? Is there any sort of collection? Is there any part of that collection process that we can push back on as not being credible, not being reliable, not being the standard of care? Do they have the ability to bring that into evidence and prove that up through expert testimony? So there's the existence itself is not necessarily a make or break. Does it make a case stronger? Does it create one more hurdle on the defense side? Absolutely, but it doesn't have to be a death knell for a defense.
Can DNA evidence be wrong or contaminated?
Absolutely. I mean, if it's not stored correctly, if it's not tested correctly, if it's not, if the durational times between when it was collected versus when it was tested, there's parameters that have to be followed there. So our job is to obviously, and oftentimes it's through hiring an expert, but to evaluate the collection and storage and testing process of that DNA and see if there's anything that would be inconsistent with how that's collected, or any sort of weakening factors through that process.
And that's what's such a big thing about our office, employing a former law enforcement member of law enforcement has been, an amazing addition to Combs Waterkotte, because, now we have someone who is a former cop, looking at, these police reports, and also the collection of the DNA evidence, and he knows the procedures and things like that. And of course, we look up the statutes on how it is to be collected and preserved and tested. But yeah, no, as Josh said, and I think it was very well put, it's not a death knell to your case necessarily.
Can a rape kit be challenged in court?
Yeah.
Same as DNA.
Yeah, same as
DNA?
Yeah. How was it collected? When was it collected? How much time had passed between when they're alleging the incident occurred and when the kit was actually conducted? Who conducted that test? How was it stored? How was it processed? All of those types of things.
Can a sex crime case be dismissed without DNA evidence?
Yeah, and it happens in many dismissals, because you have to recall that DNA evidence is not going to be critical evidence in every single case. Only, a handful or a collection of cases are actually going to have DNA evidence present. So if there are grounds for dismissal based on inconsistent statements, or the alleged victim or witness recanted their statement, or there's a affirmative defense of an alibi or consent, or whatever the defense may be that resulted in the state's attorney dismissing that charge for whatever motivation the state's attorney dismissed it, it absolutely can be done without DNA evidence.
And I don't know if you would agree, Josh, but at least I think with the most sex cases that we see, we don't see DNA in many of our sex cases. Now, of course, DNA is evidence in some of them, but we handle hundreds and hundreds of sex cases, each year. And I would say it's few and far between that DNA is involved in a sex case. Would you agree?
I would agree. That's often not the critical piece of evidence that is being evaluated. Oftentimes it is
The allegation.
It's the allegation itself. Yeah.
How do credibility issues affect sex crime cases?
I think it's paramount.
Yeah, I would say it's one of the most important avenues in which cases are dismissed.
What I just said, that, on the hundreds and hundreds of sex cases that Combs Waterkotte handles, we don't see a ton of DNA evidence. The majority of these sex cases are allegations made by the alleged victim. So, unfortunately, in the state of Illinois, we don't get the benefit of being able to take a deposition, a pretrial deposition. However, the truthfulness and the veracity of an allegation is critical in sex crimes cases. I mean, sometimes that is the case. That is the entire case, is the allegation, and therefore the truthfulness and veracity of the allegation. I mean, that's the entire case.
You're looking at questions that frequently come to mind. What is the context of the relationship?
Mm-hmm.
Has this person made allegations in the past that were considered unfounded? Is there, would there be some benefit or gain for having these allegations?
I was going to say that, a motive.
Was there a motive to having these allegations out in the stratosphere affecting somebody, for example, in a family law case or in a breakup scenario or something like that? Anything that I have said has come through the door at some point.
Can a lie detector help my case in Illinois?
Yeah, Chris is a huge proponent of lie detector tests.
Yeah, so I am a big proponent of it, and the reason I am is because, early on in my career, I was advised by my mentor at the time, how helpful those can be, and I have been able to prevent charges from being filed, and I have spoken to other members of the defense bar, other defense lawyers, that also are big proponents of the polygraph examination. And law enforcement puts a lot of importance on a polygraph. Now, we will conduct our own privately. If our client passes, of course, we're going to produce that to the state, and oftentimes they ask for the graphs and the charts and things like that. But one good thing is it's kind of a free roll of the dice, because you conduct your own polygraph. At least the guys that we use, they're so well trained that, they'll call me and say, look, we did the interview. You don't want this guy taking a lie detector test. You know what I mean?
Right.
So you kind of get a good idea. You can take a barometer on your client and kind of see where you stand based upon. And I trust, our former 27-year former sex crimes detective, who now sits on every polygraph board, has every accolade imaginable, and he's telling me, look, you don't want me to test this guy.
Right.
It's like, okay. But if he says, look, let's test this guy, and you pass, I mean, I have been able to prevent many people from being charged based upon a successful polygraph. So I will always be a huge proponent of that.
What happens if the accuser has a history of false allegations?
This is common.
Yeah, it is our purpose to utilize those previous allegations if we can get a history and a motivation behind previous allegations, and if those allegations have always resulted in being unfounded, especially if it's with the same person. We use that as part of a credibility defense. Are you, hypothetically speaking, this is now the one that you want the state's attorney to believe? The state's attorney and law enforcement has pursued 3 or 4 of these same types of reports, and they've all been unfounded, and this is the one. Now, it may be that 4th or 5th one is founded, but it's our job to suss all of that out and use that as part of a credibility defense.
And that's when it comes into play, how important it is to investigate the alleged victim in these cases. And, I think we see, or at least I see, a lot of sex cases where the alleged victim has mental health issues. Whether it's a child of, a parent and, or things of that nature. But no, that is incredibly important in any sex case.
Well, let's talk about digital sex crimes, internet-related offenses. Is sexting illegal in Illinois?
In of itself, it is not illegal. The things that make it illegal, are you disseminating pornographic images of children? Are you having pornographic or sexually motivated conversations with minors? Are you disseminating pornographic or sexual content of another adult without consent? So sexting by itself may not be considered a crime, but there are certainly crimes that can arise out of those types of conversations.
Can adults be charged for sexting in Illinois?
Absolutely. You can be charged at a felony level for example, if you are sexting with another adult and you then disseminate the content of those messages or videos, images to somebody else without consent.
Commonly referred to as revenge porn.
Revenge porn is kind of the term of art within prosecutors, state's attorneys, defense attorneys, things like that. They're called revenge porn statutes. So that is a felony level offense, disseminating that without consent. Adults can be charged with sexting with minors, obviously, because that in of itself, based on the age classification, is felonious behavior. So yes.
Can minors be charged for sexting in Illinois?
Yeah, so there's going to be several caveats with minors conversing with other minors. Once again, there are going to be prohibitions on what we would call revenge porn or the dissemination of sexual content or pictures or videos or things like that without the consent of that other person. So there's special criminal statutes pertaining to juvenile behaviors.
What is the unlawful dissemination of private sexual images in Illinois?
Simple answer to your question is you receive, likely in confidence, some sort of sexual message, picture, video, and then you send that to a third party without the subject of that picture or the sender without their consent.
So is revenge porn a crime in Illinois?
Revenge porn is a felony level offense in the state of Illinois.
Can I be charged for sending unsolicited images in Illinois?
Absolutely. Yeah, if you are in possession or you were sent something in confidence or privately that'd be pornographic, sexual in nature, and then you take that, and without the consent or without the approval of the subject or the person that sent that to you, and you send it to your buddy, you send it to whomever, you send it out. A lot of times people will disseminate this in an even more public way as a method of blackmail or what have you. That all is felony level behavior in the state of Illinois.
What is internet solicitation of a minor in Illinois?
Internet solicitation is often, they have defined it as grooming, but essentially it is the effort to seduce or solicit or lure for sexual gratification or sexual purposes a minor. So, I mean, even just the efforts or the conversations, if the conversations drift into sort of sexual territory, that itself can be considered grooming or, based on your question, of felony level activity.
What is grooming similar to Missouri law in Illinois?
Yeah, so in Illinois, they've got, it's kind of an interesting law, actually. So you can be charged with grooming for trying to, through sexual communications, or the statute itself is the purpose of the communication to elicit some form of sexual gratification or sexual response. And so you can be charged criminally for grooming if you have been expressly told that someone was underage, but also there is a line in the statute that says for what you believe to be someone that is underage. So, I mean, even if you are communicating in this day and age with AI, people do that all the time, and for whatever reason, this AI bot or chat bot, or now it's being utilized by law enforcement in their sting operations, but we have clients that are being charged, that have been charged just through communications with where there is no victim. But the question that the state's attorney has to present to the jury, and the answer that they are seeking, is that the defendant knew or believed that that person was underage. It doesn't. So
Wow.
I have heard judges call it a victimless crime because it's not a real person. It is, but it's just based on what the defendant believed when they were the intention.
Yeah.
Whereas in Missouri, it's more so kind of what you see with Chris Hansen on like To Catch a Predator. You know, it's you take an overt act to go meet someone, you know, in a hotel room or things of that nature, and you show up and surprise, surprise, it's law enforcement. So the grooming thing is a very unique issue to Illinois, and that's why, you know, I had Josh answer that question.
Illinois does not require that you get in your vehicle and go try to effectuate some sort of meetup. It can be done without any effort to do. It can be based on the conversation alone.
Really?
Yeah.
Wow.
So that's kind of the stark difference I was mentioning.
That's a stark difference between Missouri and Illinois. Can online chat logs be used as evidence in sex crimes in Illinois?
Yeah, and they often are. They'll be subpoenaed typically by the state's attorney's office as a result of the case that's ongoing, and they'll utilize that as evidence of specifically. So if you're talking about, once again, with the grooming statute, they'll utilize those chat logs to demonstrate the intent or the knowledge of the defendant as to the age of the alleged victim or witness. As far as, you know, you go to revenge porn type of analysis, I've talked to people that have been accused of revenge porn that have disseminated private images onto Reddit, onto other sort of dark web, you know, these chat environments, and so all of those can end up getting subpoenaed as well.
If you can find them.
If you can find them, yeah, and that sometimes becomes a problem, is because in some of these avenues of communication are not the most accountable.
And what if I never met the person in real life in Illinois or any state, really?
It really doesn't matter if you've never met them. For example, on the revenge porn, I mean, were you in receipt of content, or conversations, pictures, videos, things like that
Unsolicited advances
that
of any
are
sort,
of a sexual nature. And did you disseminate those? I mean, that happens all the time, especially in this age of social media. People engage in those kind of conversations and all that kind of conduct without ever meeting one another, and then disseminate it and can end up being charged on that basis.
Wow. Can the police pose as a minor online?
Yes, and again, we kind of touched on that, but that sting operation is that you see on TV. I mean, that happens. You see law enforcement posing as minors on the internet, on a phone call. I just mentioned, showing up to a meetup location, and you open the door and it's 6 law enforcement agents sitting there, not the minor that you expected to meet. So, yes, they can and will pose as minors.
So are online sting operations legal in Illinois?
Yeah, they are often utilized.
What is an indecent solicitation of a child in Illinois?
It's going to be the request for that sexual content or the conversations of a sexual nature.
And what is traveling to meet a minor, and how is that charged?
That's also considered a felony classification. That is where there is an effort or overt act to go meet a minor for the purpose of sexual conduct, sexual gratification, those types of statutory terms.
Let's talk about child sex allegations and DCFS investigations. Now, what happens when DCFS investigates child sex abuse in allegations of any sort in Illinois?
Certainly. So DCFS or Child Protective Services investigations are often the catalyst for criminal charges coming later. And the reason why is because minors will say things or demonstrate things or behaviors or report things to individuals that would otherwise be considered mandated reporters, who will then get in contact with these agencies, and these agencies can begin their own investigations. They can turn their investigations over to law enforcement or state's attorney's offices. So oftentimes through mandated reporters going through those types of agencies, that is the first domino.
Can DCFS take my kids based on allegations?
They can, yeah. Now it is a process. It's based on a different statutory scheme in Illinois that's different than the ultimate charging. So I mean, there are certainly times where an incident or an individual will be hotlined, and then that hotline may come back as unfounded, and the state's attorney may. And I've had that before, where the state's attorney has investigated deeper and has ultimately filed charges. Or I've also had instances where the state's attorney's office has not picked up criminal charges, but DCFS or Child Protective Services, still based on their analysis and their statutory factors that they have to follow, deem the child to be at risk. So they are independent operators.
But all obviously working with the same goal in mind, right?
Correct, yeah.
Protect the child.
Correct.
Can DCFS interviews be used in a criminal case in sexual abuse in Illinois?
Yes, and they often are.
Yeah, and to Chris's point, that is typically one of the first instances or the first conversations or interrogations that is turned over as part of a discovery request.
And I just had a case where this gentleman called me. His daughter made an allegation. He didn't hire us. He said, I think that when she goes through this interview, she's going to recant. Mm-hmm. And he then later calls us after her interview and realizes, I made a mistake. I need a lawyer. So that is oftentimes the first thing that happens, is a disclosure is made, and then there is an interview that takes place, and then that's when law enforcement, as Josh said, it is typically the catalyst to criminal charges, this initial interview with DCFS.
Do I need a lawyer for a DCFS investigation in Illinois?
Absolutely.
Yeah, absolutely.
Really?
Because they're going to be asking you the same. You said it well previously. Their common objective is going to be the best interest of the child.
Sure.
The state's attorney's office is obviously pursuit of justice, but that can be one and the same with the best interest of the alleged victim or whomever. So the nature of the questions are often going to be parallel. So you are going to be asked incriminating questions in a DCFS or a CPS investigation through a social worker or a DCFS investigator that you would talking to a law enforcement agent or detective or whomever.
What if the child made allegations during a custody dispute?
I mean, it often happens.
Yeah, you see that a lot. And whenever those types of circumstances hit my desk, I mean, you look at, okay, what is the temperature of the relationship between the parents that are now largely in dispute over custody determinations? How old are the allegations? Sometimes I've got a custody case going on right now where there is an allegation of sexual abuse from 10 years before.
Oh,
and
wow.
in the meantime, they've had multiple children and have moved and have been kind of this big happy family. And not to discredit, but there are certainly questions as to, okay, you take the kids out of the house and then you file that allegation or report that allegation. And so that's not to make a determination at this point, but it lends itself to at least an analysis of credibility. And during custody cases, disputes, modifications, you do have to be suspicious of motives and add that as part of your overall view of the evidence.
Sure. I mean, you have a 15-year-old alleged victim who's now saying that, she's having dreams of when she was 5 or 6 of, something happening. Again, not to say that it's just completely unfounded, but we've got to, really look at that through,
Sure.
a different lens.
A manipulative tactics could plant
Sure.
those types of
Yeah.
thoughts.
And you see a lot of parents coaching their kids,
Right.
in these family law cases, and it's really nasty. I mean, it can get really nasty quick.
But we can engage psychologists, we can engage therapists, we can engage psychiatrists. There's a lot of things that we can do.
Can teachers or doctors automatically report potential abuse?
Yeah, and they're just several folks that are on a mandated reporter list. So you're going to have, teachers, doctors, coaches, DCFS personnel, Child Protective Services personnel, social workers. All of those types of individuals are mandated reporters.
What if an allegation is based on manipulation or coaching in Illinois?
Well, you have to determine when that coaching took place, how it took place, what's the extent of it. Was it something where the child went in and said, I was told to say this, or is it something where you get the transcript back or you're reviewing a video footage or an audio recording and you're just going, there is no way. Oftentimes what you'll see is
Vocabulary. Right?
words that are completely unreasonable to have an understanding of their context and proper usage being used over and over and over again. And you kind of are trained to your
Pick up
spidey
on
senses
that,
kind
right?
of, yeah.
Sure. I mean, you see a 6-year-old that's using words that are just not age appropriate. It's, something that, a 10 or 12-year-old wouldn't even know the meaning of that word.
Right.
You have to think, someone's feeding them this information somewhere.
Right. Well, can child interviews be challenged in court?
Yeah, any evidence like that would potentially be used against you, you have the ability to review it, evaluate it, and then make attempts to discredit it.
What is forensic interviewing in a child sex case in Illinois?
Forensic interviews are going to be conducted largely through interviews with like social workers, things like that, crime victim, special, I would call them child or minor crime victim advocate type of personnel. they're going to go in often in an isolated setting and ask those questions outside of the presence of attorneys or parents or judges or anyone like that.
Go
They're
ahead, I'm
not
sorry.
supposed to ask leading questions, you know. They're there to try to get the objective truth. So, you know, Josh can, of course, explain, you know, how it works in Illinois, but again, you get to challenge the child advocate who did the interview regarding some of the types of questions that they asked and things of that nature to elicit certain responses.
And some of that's going to be subjective based on the age of who potentially could be a victim or witness in it. So, I mean, if you're dealing with younger elementary age, I mean, the questions are going to be, oftentimes you'll hear, what scares you? Does dad get mad? Does mom get mad? You know, but then if you're reviewing the transcripts of a forensic interview with a 15 or 16-year-old, it's obviously way more
Different.
in-depth. Yeah.
Right. Well, can a child be forced to testify in a sex case in Illinois?
They can. Now, it's going to be based on a determination, and often the judge is the one that makes that determination of whether that cross-examination or that direct examination can occur without too much trauma suffered by I hesitate to say child, I'll say minor. Because if the judge makes a determination that a 14 or 15-year-old can credibly testify and be cross-examined, then you have a constitutional right to confront all the witnesses against you. That constitutional right does not disappear. However, courts and legislatures have created tighter scopes of how that information is accessed. So, for example, you'll hear in-camera interviews, and that's basically where the judge will then go conduct an interview with a minor, basically that's outside of any sort of outside influences.
You know, and I was recently talking with my law partner, Steve Waterkotte, and he was like, you know, I always get the question, what's the hardest part of my job? He's like, and, you know, I always forget how to answer that. He goes, but yesterday, I just remembered what the hardest part of this job is without, you know, having to think twice. And he said, cross-examining and or taking the deposition, which again, you can't take a pretrial deposition in Illinois, but in Missouri you can sit down and take the sworn statement of a minor. He said that is by far the toughest part of being a defense lawyer is, you know, challenging the veracity and cross-examining a minor. It's really tough.
That's got to be terrible.
It is. It's not.
As a parent,
Yeah.
especially.
Well, it's horrible for everyone.
Yeah. Well, let's talk about the sex offender registration. Will I have to register as a sex offender in the state of Illinois? Hopefully you'll ask me now,
Yeah.
have I committed the crime? And no, I have not. So
Yeah.
hypothetically,
If someone has been convicted of a sex crime, in most sex crimes, and certainly all high-level sex crimes, things criminal sexual assault, criminal sexual abuse, aggravated enhancers to either one of those, child porn, any grooming, whatever the charge may be, there is certainly a real likelihood that you'll have to register.
what crimes require sex offender registration?
In my personal opinion, it's generally all of the sex crimes that we've previously been discussing. You're looking at criminal sexual assault, criminal sexual abuse, certainly all the predatory criminal sexual abuse or predatory criminal sexual assault. There is registration requirements for for convictions regarding minors, like traveling to see a minor, those types of classifications. Anything that I've previously mentioned is going to require a registration.
And of course, there's different tiers of registration. And I would say we get at least 2 or 3 calls a day of people whose cases we did not handle, but who are looking to either get off the registry or maybe we get this a lot too. Hey, I used to live in Iowa, and they had me as a tier 2. Now I moved to Missouri, and they've reclassified me as a tier 3. So there's actually a lot of registration cases that we see. Like I said, at least 1 or 2 calls a day regarding registry. Can I get off? Can I get dropped a tier? So luckily we have a former sex crimes prosecutor in our office, Matt Brown, and he was actually selected as one of only 15 prosecutors when he was a prosecutor nationwide to go train on computer sex crimes and things like that.
Wow.
With the FBI. So, that's a huge asset in our office, and he's very well versed in, sex offender registry and requirements and things like that. But almost all sex cases, as Josh said, will result, if you are convicted or if you accept a plea and enter a plea of guilt, will require some type of registration.
Well, how long does sex offender registration last in Illinois?
I would say there's 2 well-known classifications. One would be a 10-year registration. The other would be lifetime registration. And that's going to depend on what you were convicted of, found guilty of, pled to. Obviously, think the more serious is probably a sort of an understated word for it, but basically the more egregious the actions that can be proven, and also whether or not there's aggravating or enhancing factors.
The higher level, the felony.
Higher level, the felony. Right. Yeah. If you're in Class X realms or classifications of felonies, and there's repeat offenses and different things like that, can differentiate between a lifetime registration versus a 10-year registration.
Can I ever get off the sex offender registry in Illinois?
If you are subject to a 10-year sex offender registration requirement as a result of a conviction, plea, some sort of disposition, then you can petition and undergo a petition process once those 10 years have been completed.
What is the Illinois sex offender registry?
It is a registry that's maintained through police department and other government entities and agencies, requiring people that are found or individuals that are found guilty or convicted of these sex crimes. It is essentially a database to track their location, where they live, what their occupation is. It tracks what access they have or specifically don't have to social media. It tracks what they've been convicted of or charged with. It tracks when they no longer have a registration requirement, or do they always have a registration requirement. Any sort of special conditions that may be imposed on their registration requirements. It's the state's general database for all that information.
And it's extremely strict. We see another influx of calls regarding failure to register. And that can be based off of a move and not updating your address. I mean, it's very, very stringent.
Will being on the Illinois sex offender registry affect where I can live?
Absolutely. A byproduct that is often the case is you're not permitted within 500 feet of schools or parks or other locations that are primarily occupied by minors. Can be certainly one classification. So it can affect your personal liberties. It can affect your employment. It can affect your access to housing. All of those things.
Can I live near a school if I'm on the Illinois sex offender registry?
No. I would say I'm not even aware of really caveats to that. Typically, you're not permitted within 500 feet.
Can I travel out of state if I'm on an Illinois sex offender registry?
I think that would be a question that could be answered based on whatever specific registration requirements. But one of the things I am aware of is that you do have to at least report anytime that you are relocating or traveling. There's durations that you have to report so far in advance of anything like that.
What if I fail to report as a registered sex offender?
If you fail to report and law enforcement catches up with you, which they will, because there's so many different elements of accountability that you're required to maintain or follow. If you fail to report, then it can be charged as an additional felony.
Is failure to report a felony in the state of Illinois?
Yeah, if there are allegations that you have not reported your status, you have not reported a move, you have gotten a new social media site that you did not report, all of those are instances off the top of my head that I can think of that I've had clients call in and have been charged with a failure to report based on circumstances like that.
Can a juvenile be required to register in Illinois?
Yes, they sure can. One of the things that's going to be different about a juvenile registry is once they reach that age of adulthood, then there is a specific process for a juvenile petitioning once they have completed their reporting requirements and their juvenile disposition of that case. Once they've completed all their obligations and once those factors have all been met, then they are able to petition to get off of that juvenile. So in that is certainly fact intensive. So to provide you a completely clear black and white answer on that would probably not be wise. But generally that's the process. And so then a petition will be filed in the court in which their sentence or their disposition was imposed. And that's going to, once again, be a determination of do they qualify under the statutory requirements? Are they no longer a threat to the community at large? Things like that.
Well, let's talk about sentencing and prison consequences for sex crimes in Illinois. What are the penalties for criminal sexual assault in Illinois?
The penalties for criminal sexual assault, depending on whether it's aggravated or not aggravated, it certainly would be prison eligible. And then if you start moving up into like the Class X classifications of that conduct or behavior, then you're looking at mandatory prison time.
What prison time can I face for aggravated sexual assault?
So if you're getting into the realm of aggravated or enhanced, basically higher, beyond the fact that you're at a higher level felony, there's also some conduct incident to that. For example, was their utilization of a firearm during that process, during the incident alleged, then you can have additives to your sentence of 10 years, 20 years, etc.
Do sex crimes carry mandatory prison sentences in Illinois?
Yes, they can. The higher level ones can certainly, once they reach those Class 1s, Class Xs, they are no longer probation eligible.
Can sex crimes ever result in probation in Illinois?
Depending on the type of felony that you are charged with. For example, there are Class 2 sexual abuse felonies that are probation eligible. There are Class 4 grooming charges that are probation eligible. But once you start getting into aggravated criminal sexual assault, things where there's allegations of those types of behaviors with minors, then you're often looking at charges that are not probation eligible and require some Department of Corrections commitment time.
What's the minimum sentencing for predatory criminal sexual assault in Illinois?
So, once again, it depends on if it's just at its base level or whether or not it's enhanced. But it would be 3 years.
What enhancements apply in Illinois sex crimes?
There's a number of them. One of which that is very frequent was their utilization of a firearm. Did the alleged incident take place with a victim that is considered a special victim? For example, were they disabled? Were they over the age of 60? Was there a bodily injury that occurred as a result of the incident? All of those facts can be utilized by state's attorneys to try to enhance or file enhanced or aggravated charges.
What happens if the alleged victim is under the age of 18 in Illinois?
That's going to dictate what kind of charge or what classification of charge the state's attorney's office has available to them. But still within that, was there Are they claiming that it was conversations only? Was it traveling to meet a minor? Was it grooming? Was it touching without any sort of penetration or anything like that? Did it revolve express sexual contact? All of those things give rise to potential classifications of charges that can be filed for specific to minors only.
What if there's an age gap between the parties?
If that age gap is such that, for example, under the statutes in Illinois, one of the charging classifications was the defendant at least 5 years older and did the alleged victim, in this case, fall between the ages of 13 and 17, then those age ranges or those specific that age gap can be used as one of the elements that the state's attorney will evaluate based on the facts and how they bring that case and what they charge.
What happens if force or threat is alleged in the misconduct and sexual assault?
Depending on the type of force, if it results in some form of bodily injury, if that force is conducted through firearm or threat to use a firearm or threat to kill, or with any sort of weapon or anything like that, then oftentimes the state's attorney will utilize that fact as justification for filing the charges under an aggravated umbrella.
What if a weapon was involved in a sexual crime allegation in Illinois?
Yeah, so whenever a weapon is involved, whether it be an allegation of sexual assault, whether it be an allegation of sexual abuse, it will act as an enhancer. And what that means is basically that the state's attorney then has the discretion and has the opportunity to file those charges as aggravated, which are then going to come with greater penalties and greater potential prison sentences. They're going to render those charges as non-probation eligible, so that having a weapon involved or an injury involved or something opens the door, unlocks a greater range of charging statutes.
Can I get court supervision for sex crimes in Illinois?
It is not likely for any of the significant. When I say significant, I mean Class 1, Class X, aggravated. Many of those are not even probation eligible. Whenever you get into Class 2, which can be, sexual abuse, which is unwanted conduct or unwanted touching. If you get into traveling to meet a minor, revenge porn, grooming, those are still probation eligible, but you're likely not looking at opportunities to get court supervision on those cases.
Let's talk about expungement, sealing, and record consequences. Can a sex crime be expunged in the state of Illinois?
My answer to that is vehemently going to be no, and that's going to be based partially on the fact that it's a sex crime, but partially on the fact that Illinois does not allow for expungements. Generally speaking, obviously there's exceptions, but Illinois does not generally allow for expungements where there has been felony convictions. So because all of the sex crimes that we have discussed or that are commonly discussed are felonious, then that by itself, if you're convicted, then that by itself would render them unqualified for expungement.
Can sex crime convictions be sealed in the state of Illinois?
That's often not the case either. And once again, it's based on the fact that it's conviction, then also based on the fact that it's the conviction based on the alleged conduct. Obviously, the legislation has deemed it public policy for that information to be public.
What happens to my record if the charges are dismissed?
If charges are dismissed, then it does potentially unlock an opportunity to expunge or seal the arrest records. That would at least be a difference between a conviction and a dismissal, is that Illinois does allow for processes to be in place to try to remove the arrest records, because if a case is dismissed against you, then chances are, for whatever reason, that was not it was not strong enough to be pursued or prosecuted. So that is why the restrictions are less when someone wants to expunge or seal their arrest records.
Can I remove an arrest record after a sex crime case?
So the process would be to file a petition in the county in which the arrest took place to expunge or to seal those arrest records. And that's going to be based on the charge that the arrest was made for and a number of factors. I mean, and then the judge has the determination of evaluating, is it in the public's best interest to have those arrest records sealed or expunged? Do they qualify under Illinois statutes, et cetera?
Will a sex crime arrest show up on a background check?
I tell clients this. I mean, even in instances where we are able to successfully, and this is generally speaking, but where we're able to successfully expunge arrest records or seal arrest records, that jurisdiction is going to be at a state level. And so the state of Illinois, a judge in the state of Illinois may order that those arrest records be expunged or sealed, but there are certain federal background checks, for example, for insurance agents or brokerages or things like that, where they may still be able to see those records.
I'll just expound on that.
Great.
So you are essentially, when you are doing an expungement of arrest records or trying to seal something, and again, this goes for, any state I'm aware of, as Josh was saying, you are getting a court order from a state circuit court judge saying seal these arrest records. Mm-hmm. Well, one of the places you're going to send that order to is the NCIC, the National Crime Information Center. It's a federal database. Well, supremacy clause in the Constitution, federal law trumps state, they'll likely ignore that. So your fingerprints get scanned, likely it's going to show up. So getting something completely erased to where it's never showing up again, highly unlikely. Wouldn't you agree, Josh?
I would. And now,
there's an agency somewhere that's going to be able to see it.
Now, for your run-of-the-mill screenings for
employment,
that does not require federal licensing or accountability, it's a great idea. For housing applications, it's a great idea. But you just have to be aware that it's not completely gone.
And I think one surefire way to know if it's going to show up is if the background check requires fingerprints, it's likely going to show up.
Wow. Can I get a FOID card after a sex crimes case?
No, you cannot. And actually, and to answer your question directly, no, you cannot, because you cannot possess a FOID card or have access to firearms after a felony conviction in Illinois. But oftentimes, you are required to surrender that even based on allegations.
Wow.
So, and that can be as a result of the allegations of the case, and also, for example, I've had individuals that have had to surrender their FOID card just based on allegations of domestic violence, or orders of protections can have a requirement in there that a FOID card is surrendered and firearms are surrendered.
So can I own a gun with a sex crime charge in Illinois?
If you've been convicted of a sex crime in Illinois that gives rise to the evaluation is not necessarily whether it's a sex crime or not. The evaluation of whether or not you were convicted is whether or not you were convicted of a felony. If you were convicted of a felony under state laws, and then likely federal law would come into play too, you are not lawfully able to possess a firearm. So possession,
charged, convicted,
possession versus ownership.
Allegations.
Yeah, so possession of a firearm, ownership of a firearm, much of that is semantics, because if you've been convicted of a felony, then no, you're not able to.
It's a little bit more straightforward. I know you're saying, allegations.
It's like which one you can get your FOID card taken away for allegations. You could lose your rights to gun ownership for allegations or for charges.
Sure. I think the simple way to look at it is if you're convicted of a felony, you're not possessing firearms
Fair enough.
That's one kind of like straightforward way to look at it. However, there are nuances, and that's again, why you want to speak to an attorney,
Sure.
To see your rights of carrying a firearm and having a FOID card.
Will a conviction of a sex crime affect immigration or deportation in Illinois?
Yeah, it absolutely can. And some of that is based on the allegations themselves, and some of it's based on the fact that all of that conduct likely gives rise to a felony level. And so if you are convicted of a felony or being investigated for a felony, then you are automatically, the awareness of your immigration status is going to be escalated or more heightened with the agencies that evaluate that type of thing. So, and frankly, I've got clients that are in pending various immigration status during pending cases, and that may result. And even though they have not been convicted or found guilty or anything like that, they are already on holds or detainers or on watch lists, things like that. So even the allegations themselves can trigger higher scrutiny.
Wow. Can I lose professional licenses based on sex crime allegations?
You certainly can, and it happens frequently. And the reason why is a lot of these applications for professional licensing require near perfect or completely justifiable criminal records. And so if you are convicted of a felony itself, then that may disqualify you. And certainly where there's going to be trust placed in you, or you are a caretaker provider, even felony convictions or misdemeanor convictions outside of the context of sex crimes can prohibit it. But when you add in the allegations that are often associated, or the conduct associated with sex crimes, that certainly can preclude you from holding many types of boards or licensing, whether that be state or federal.
So let's get into false accusations and protective steps. What should I do if I'm falsely accused of a sex crime?
Hire a lawyer, as Josh said earlier, and that we discussed, what do you want to do when you're falsely accused of something? You want to scream out your innocence.
Of course.
Obviously, that is your knee-jerk reaction, but that is not the action you should take whatsoever. That is when you hire an attorney, you give your version of events to the attorney, and again, that's when I become a big proponent of the polygraph. Just put a lawyer between yourself and law enforcement, because, again, allegations are enough to result in criminal charges. If false allegations are made and law enforcement take those allegations and they believe them to be true, which often they do, and they take them to the state's attorney or assistant state's attorney, and they believe them to be true, which allegations are enough, testimony is enough, they sign off on, look, there's probable cause that a felony was committed here or a misdemeanor, then boom, you're charged. So then it's our job to prove that it's false, that there are false allegations. And that's tough. Sometimes you can't prove a negative, right? You can only say, I didn't do this. But again, it's our job to challenge the truthfulness, the veracity of the allegations. False or not false, really. Josh?
Yeah, I would agree.
Some people think, I'll just call the accuser and I'll just clean this whole thing up. I'll set him straight.
It's the worst thing you could possibly do. I mean, literally the worst thing you could do. You don't ever want to reach out to an alleged victim in any type of case.
So calling the accuser could negatively affect the case.
You could catch other charges. You're really just making your situation 10 times worse.
What evidence should I save if I'm accused?
Everything you can possibly save.
Yeah, I would agree. I mean, I would start logging all the conversations that you've had. I would, if it involves potential third-party witnesses, identifying who those individuals might be, summarizing any sort of contextual history, like relationship history, anything like that. securing any alibi information, depending on the charge and depending on your affirmative defense. I mean, as detail intensive as you could be is probably best, because then it allows us to have a stronger leaping off point whenever we go and have those conversations with detectives or state's attorney, depending on where we're at in the case.
Sure. Can witnesses help in sex crime cases?
Yeah, often they can. And they can testify as to, and they may not be able to necessarily testify as to the specific moment or the specific action, but they certainly can testify as to what they witnessed around
Character.
that time frame.
Yeah, of course, the truthfulness, is
Yeah.
this person to be believed? Just like a witness in any other case.
What happens if the accusation of sex crime is retaliation or revenge?
We see that. We talked about it in family law cases.
Yeah.
So it happens. It's just, again, it's something that defense attorneys have to battle.
Yeah, and it's not as though that my position is that anytime anyone is accused, it's because of that. But our process does involve evaluating the context and the motive every single time. And so if we can build a defense based on what we would call probably red flags, I mean, did the accusation come quickly on the heels of something like a breakup or a family law dispute, or was there some sort of retaliatory context within that interpersonal relationship? I mean, that is a huge point for us to raise whenever we're given the opportunity to either cross-examine or provide a defense.
So what happens if allegations come from a breakup or a divorce? How do you fight that?
You certainly catalog it, and you evaluate the chronology. What was the relationship like before that allegation was made? Is it something where there has never been any type of allegation like that before, and now, as soon as there's tension or as soon as there's dispute, now that comes about? Okay, if that happened during a period of time that was in the distant past, then why are we just now raising it? And that's not to say that it's completely incredible, but it certainly does provide somewhat of a red flag that we would evaluate.
And details are so important.
Exactly.
Details.
What if the accusation involves in child custody? What do you do then?
It becomes a piece of the puzzle. You evaluate the motive behind the reporting of it, and the motive may be good, or the motive may be pure or innocent, or however there may be absolutely no problems, but that is part of our intake and our screening, and the evaluation of details is setting out a chronology of everything and a timeline. And so if there were no allegations before someone filed for a modification of custody or for primary custody, but suddenly now one of the parents is alleged to have engaged in all this conduct, then that is a very ripe field for us to cross-examine and try to at least get an idea of how credible that report is if it's solely existing within this context of conflict between these individuals.
What's it look like when you prove an allegation of a sex crime is false? What's that look like for an attorney?
Well, you don't have, and I say you, the defendant does not have the burden to prove anything. That's always going to be the state's burden. But that does not mean that we're not able to provide a veracious defense based on whatever's alleged. So to answer your question, what that looks like is if we have worked the case up diligently enough and thoroughly enough to where the evidence that we've acquired on our own side of the fence completely refutes the allegations, whether that be through witness statements, timelines that don't match up, alibis,
Text messages.
acknowledgement of, sometimes that looks like the alleged victim or witness going in and recanting their statement. All of those things, to answer your question, what dismissal looks like or what defense looks like is when we have been able to present those things, whether by themselves or kind of a combination of all those things, and take that to the state's attorney, and they go, yeah, we're not taking this case to trial based on those events.
Well, that's what makes a big difference.
Yeah. Yeah.
Providing that defense for someone, falsely accused or allegedly accused of any crime, really.
Certainly.
In a sense. This is a difficult subject, and
Certainly
I
is.
yeah, and I'm grateful that you guys took the time to come over and have an in-depth conversation. Because I think most people aren't aware what goes into the diligence that goes into protecting, defending, supporting, and caring for your clients. And I think Combs Waterkotte is that's one of the greatest traits of your firm, is that you do more than just catalog a client and take their case to the finish line. You do all the stuff in between, which is, I think that's a big deal, especially cases like this. I mean, this has to be a challenging time in anyone's life. Accused, alleged, you
Have your children taken from you.
your children
move
taken
out of
from
your
it's
house.
terrifying. It's a terrifying situation. But anyway, I'm grateful. It was Combs Waterkotte. We've got managing partner Chris Combs with us, the lead Illinois attorney Joshua Boardman. So grateful you guys came by again. I hope we get to see you again soon. Thanks again for joining us. We'll see you next time, Paxton Studios.